Welcome back to Stinging Back, the podcast where we expose the truth behind online sting operations and the deceptive tactics that law enforcement and vigilante groups use to entrap and shame people for profit and political gain. I'm M.
And I'm A. And today we're diving deep with our guest, L, an attorney who's begun taking a closer look at how these things operate and why they've been able to thrive for so long, virtually unchecked. The title of today's episode is Unmasking the Legal Lies, Deception, Entrapment, and Fraud. L, thank you so much for joining us.
Thank you for having me, A. I think having more of an understanding of entrapment, sting operations, and how law enforcement can act unchecked in these kind of scenarios is important for the public to understand. I want to make a quick note, though, that the info that I'm going to share here is based just on my general experience and research, and I don't want it to be kind of perceived as any kind of legal advice and shouldn't be taken as guidance for any one specific case. If you or someone you know has been involved in a sting or is facing charges, the best thing you can do is speak with a qualified criminal defense attorney licensed in your state.
Good advice. How about we start with the basics? How are the law enforcement sting operations even legal when they involve so much deception? They're initiating sexual conversations or responding for adult sexual situations, posing as adults first, and then suddenly flipping the narrative to say they're minors.
That's a great question, and it gets right to the core of how these stings work. Not all are the same, but a common tactic is what's called a reverse sting, where police post ads on adult sites, often showing someone who looks and sounds like a legal adult. Only after the conversation starts do they suddenly say, "Actually, I'm underage." Legally, police argue they've got probable cause once three things happen. First, that the decoy says that they're underage. Second, there's talk of sex. And third, the person shows up to meet the person. That final step, just showing up, is usually what's treated as what's called a substantial step towards committing a crime, even if nothing physical ever happens. This bait and switch, posing as an adult, then claiming to be a minor, isn't legal in and of itself. Courts treat it as standard undercover work. But whether it crosses into entrapment depends on how it's done, what was said, who pushed for sex, and whether the person was already predisposed to something illegal or was steered into it.
So even when it's clear that the person only engaged because the conversation appeared to be between consenting adults looking for that kind of connection from the start?
Yeah, and that's where things get messy. A lot of these conversations start on adult sites between what seems to be two just consenting adults. Then suddenly the decoy says they're underage, and just like that, law enforcement flips the narrative. From there, prosecutors treat chat logs, any photos, and the fact that someone showed up as proof of intent. And that's often enough to establish probable cause, what's needed to go and arrest someone and to believe that a crime may have happened. But the problem is, we lose context within all of this. The full chat history isn't always saved, and the person being targeted has no idea they even needed to preserve it in the first place. Meanwhile, police can cherry pick what they want to keep and what to show in court. And what's worse is that these decoys are often adults, sometimes even in their 30s, using their real voices and photos. And that's crucial for a defense. But unless it's specifically requested, that evidence might never be seen, and it creates a huge imbalance in the court system.
Well, in some of the cases that we know about, the men never even went to the location where they were supposed to meet the pretend minor. They were arrested at an entirely different location. So, how are prosecutors and law enforcement justifying the claim that a substantial step toward committing a crime was taken?
That's a really important point, and it highlights how subjective and frankly stretched the concept of a substantial step can be in these kinds of cases. A substantial step is supposed to be an action that clearly demonstrates the intent to commit a crime, something beyond just mere preparation. But what we're seeing in many of these cases is cops and prosecutors arguing that sending a message, agreeing to meet, even just driving somewhere, even if the person never arrives at the intended place, can qualify as a substantial step. And in some jurisdictions, courts have accepted that if the intent is there and the person takes any concrete action towards the crime, even if it's just getting in a car or making plans, that can be enough. But when the alleged victim doesn't exist and the scenario is completely false and fabricated, it raises serious concerns about whether the person was truly attempting to commit a crime or simply manipulated into crossing that legal threshold by the sting itself. And the cases you're referring to, where someone was arrested miles away from the sting house, becomes very murky. And if law enforcement was the one doing the pursuing, coaxing, or pushing for a meetup, then it starts to look a lot more like entrapment or a manufactured crime.
Entrapment, there's that common word we keep hearing here. Now, most people assume that if you're lured or baited by police, that's illegal. But over and over, we've seen courts reject that defense. Now, why do they reject that?
Well, entrapment is a defense that says, I only went through with this because law enforcement pressured or manipulated me into it. I wasn't someone who was already inclined to do it on my own. The challenge is that it's up to the jury and not the judge to decide whether that's true. And in emotionally charged cases, especially where children are allegedly involved, it's hard for juries to step back and objectively evaluate the tactics that were used. Plus, law enforcement gets to control how the story is told, and they can decide what evidence to preserve and how to frame it. That makes fighting back with an entrapment defense incredibly difficult, even in cases where the setup was clearly manipulative. And because the government gets to orchestrate how they want the case to be presented, even before they get a target and can choose what context to save this, is where these stings get legally and ethically murky.
And we know of so many cases where it's not just murky, it's straight up dishonest. We've spoken to men who were completely misled. Law enforcement or vigilantes made contact with them on adult hookup platforms by soliciting them for this type of interaction, clearly posing as adults who were seeking a man for this, and only after initiating explicit chats or arranging a meetup do they suddenly claim to be underage.
Yeah, and a bait and switch like this, or the police not documenting all of the interaction with these men, raises serious red flags.
Elle, you've mentioned that it should be up to the juries to decide whether entrapment occurred. But what we're hearing time and time again is that defendants who try to raise that defense are blocked from doing so. Judges won't even allow the argument to be presented in court, so juries never get to hear it. Is there a way to build a stronger case up front to convince judges to let that argument go forward?
You're right, and that's a major issue. In theory, entrapment is supposed to be a question for the jury, but in practice, many judges treat it as a legal gatekeeping matter. To even get the defense in front of a jury, the defense team has to present enough evidence early on, usually through a pretrial motion or hearing, to convince the judge that entrapment is a plausible explanation based on the facts. And if those facts aren't shown, usually the prosecution can file what's called a motion in limine or a motion to preclude the entrapment defense in order to prevent the entrapment defense from being asserted. And that means that it's important for a defendant to gather every shred of discovery highlighting how the illegal conduct originated with law enforcement, and providing the defendant had no prior intent. The stronger and more specific that evidence is, the harder it is for a judge to not allow for entrapment to be argued outright.
So basically, if defense attorneys don't have airtight evidence early on, even if it exists, the jury may never even get to hear about the possibility of entrapment. That feels like a huge structural problem in these cases.
And that brings me to something even more disturbing. We've seen cases where law enforcement outright lied in police reports and even on sworn affidavits. In one case, an officer claimed there was an actual minor involved to justify a search warrant when there never was. In others, they wrote that the suspect reached out to a minor online when it's clear from the chat logs that the decoy contacted the man first, presenting as an adult. And in most of the other cases, the men reached out to them because he was made to believe that this was a consensual adult seeking to meet a man for a casual encounter. They did not reach out to them because they thought this was a minor.
And how is that not misconduct? And how is that not entrapment?
What you're describing is definitely misconduct, but not technically entrapment. Entrapment is about whether the government pushed someone into committing a crime they weren't predisposed to commit. Here, it's more basic. It's about whether a crime even happened the way the police said it did. Sometimes cops just get sloppy, details get lost in the shuffle. There are also cases where they leave things out or twist facts to make the reports or warrants sound stronger. That's where things start to cross the line. And if an officer knowingly lies in a sworn affidavit to get a warrant, that could be a Fourth Amendment violation and it can be perjury. Unless you can prove they did it intentionally, courts often let the evidence in anyway under what's called the good faith exception. Basically saying, well, the officers thought the warrant was valid, so they might as well be allowed to use it. And even if the warrant gets tossed, prosecutors can argue that the evidence would have been found anyway under what's called inevitable discovery. So, yeah, lying or stretching the truth should be a big deal, but unless it's caught and proven, the system usually just moves forward like nothing happened.
And we've also heard of situations where police claim they had permission to search someone's phone when they didn't, or even accuse someone of having child porn on their device when they knew that wasn't true. That just adds more to the destruction of these people's lives that they're doing this to.
Yes, and police are legally allowed to use deception in the field when they're looking for suspects. There's a hard line they're not allowed to cross. They cannot lie in sworn legal documents that they can't make false claims to justify a search or an arrest. If they do and it's provable, there may be grounds for a motion to suppress evidence, to file a civil lawsuit later, or even criminal liability. But again, the burden is high for all of this, and it often comes down to whether a defense attorney can get access to all of these kinds of evidence and hold the police accountable.
So, Al, what can people actually do if they suspect that law enforcement lied in their case?
The first step is getting access to all of the evidence, which is called discovery in a case. That includes things like text messages, photos, and anything that was on your phone. From there, a defense attorney or a forensic expert can dig into the data to check for things like deleted messages, altered files, or missing information. If it looks like evidence was tampered with or left out, the defense can file a motion to dismiss for a failure to preserve key evidence. Even if the court doesn't throw the case out, you might also get a jury instruction saying the missing evidence would have helped your defense, which can seriously impact the outcome at trial.
Al, I have another question. You said something powerful when we last spoke. You mentioned that in order to prove that the tactics used in these sting operations are crossing legal lines, we have to show that the deception is intentional and consistent.
That's right. One-off mistakes or sloppy police work might be frustrating. They're not usually enough to rise up to, legal misconduct. What matters is the pattern and intent of the officers. You can show that the deception isn't accidental, but part of a repeated, deliberate strategy used across different stings, jurisdictions, or agencies. That's where you start building a case for institutional misconduct. It could show bias, it could show bad faith, it could potentially violate a person's constitutional rights, especially when it comes to due process, unlawful searches and seizure, or the right to a fair trial.
And that's why I think that what we've done in our advocacy group is so important. We've spoken to dozens of men, and in virtually all of their cases, the same tactics were used. There was law enforcement that targeted men who were clearly seeking a casual encounter with a consensual adult, and that is a sexual casual encounter. And then the men were targeted on an online adult platform that consensual adults use for this type of interaction, seeking those sexual conversations. And the decoy will always push to make the conversation sexual. In most cases, it was sexual before the conversation even began, because either the decoy or the men solicited others for that type of conversation. They were in a sexual environment seeking these types of conversations, seeking other like-minded consensual adults to participate in this with them. That's just not how predators work. And then the decoy will always wait until after they have lured and enticed the men with sex to drop the AIDS claim. That sounds more like a role play thing. And they always deliberately edit out that context, like deliberately omitting the important fact that they, the decoy, solicited the men for a sexual conversation with the intention of meeting them for a casual sexual encounter. They deliberately leave out these critical details to create the illusion that the men were intentionally seeking out minors online to solicit them for sex. It's all a carefully crafted deception. And in the end, the public becomes a victim of this scam as well, because they think that this is about trying to protect children from online predators when in reality, it's just not.
That's a really strong point, eh? Consistency across multiple cases is what makes the difference in court and in public investigations.
So, one consistency we've seen is that it's always law enforcement who introduces the idea of sexual activity with a minor to men who were clearly not seeking a minor. In other words, the concept of illegal conduct, this sexual conversation with a minor and what follows, comes entirely from law enforcement. It's their script, not the man's.
Exactly. Because the men they target are on an adult content platform looking for consensual adult interactions of this type, that is, sexual conversations, and maybe meet up for a casual sexual hookup after that. Now, it's not illegal for adults to be on these platforms seeking other adults for that kind of consensual interaction, right?
That's correct. It's not illegal for an adult to be an adult platform looking for consensual sexual conversations, even to arrange an in-person meetup with another consenting adult. These platforms are built for adults unless there's a clear shift into criminal intent, like knowingly pursuing someone who identifies as underage, and the behavior is protected. What matters legally is the intent and the knowledge of age, not just the fact that the person was open to adult sexual conversation in general.
So, in your opinion, if we can prove that law enforcement introduced the idea of the illegal conduct by injecting a minor into what was otherwise an adult context, would that qualify as entrapment?
It could, yes. Entrapment really comes down to two questions. Did the idea of the crime come from law enforcement? And second, was the person induced to commit that crime even though they weren't already predisposed? So if someone goes online clearly looking for an adult, and it's law enforcement that later shifts the conversation by saying they're a minor, especially if that person hesitates or pushes back, there's a strong basis for an entrapment offense. Now, if this tactic is happening repeatedly and case after case, it stops looking like an accident and starts looking like a systemic strategy. That's when the entrapment argument really gains traction legally and ethically.
And that's why this matters so much. Because we're not just talking about isolated incidents. We've spoken to dozens of individuals and reviewed case after case that show this exact pattern. Adults looking for adults, and it's law enforcement or vigilantes that introduce the illegal element. If that's not engineering entrapment, what is? We're going to keep digging into these tactics in future episodes, but for now, this is a wrap up. Stick with us. We've got more coming up on Stinging Back.
Elle, thank you so much for helping us navigate the legal maze around entrapment and deception. Before we sign off, do you have any final thoughts or words of advice to our listeners, Elle?
Yes, if you ever find yourself involved with cops or law enforcement, especially in a sting operation or anything involving serious legal allegations, the most important thing you can do is stay silent and ask for a lawyer immediately. Don't try to explain your side, don't try to clear things up. Just say, I want an attorney, and don't say anything else until you have one with you. That decision alone can make a huge difference in protecting your rights.
If you want to dig deeper into the stories we've talked about today, be sure to check out the Lady Justice Smith blog at ladyjusticesmith.blog. It offers in-depth breakdowns of real cases and uncovers the truth behind some of the most disturbing patterns in these operations.
Hey, also a big shout out to our friend Norm. His YouTube channel, ICAC Unpacked, that's ICAC Unpacked, is doing powerful work exposing misconduct in online sting operations while also shining a light on broader problems in the justice system. Both of these are excellent resources if you want to stay informed and truly understand what's happening beneath the surface.
And to everyone tuning in, please know this: we see you, we hear you, and we believe you. Your stories matter because the truth matters. And we will never stop pushing back against the lies, the manipulation, and the injustice of these fraudulent operations.
Stay strong, stay informed, and as always, keep stinging back. Until next time.